Good morning, everyone. My name is Jim Gilbert, and I'm the Director of Executive Education at Berkeley Law. I want to welcome you to our second session in our Whistleblower series. For those of you who joined us yesterday, welcome back. And for those of you who are joining us for the first time, we're really glad to have you today. Today, we're going to be joined by panelists John Phillips and Jeb White, and our moderator today is Claire Sylvia. Before we begin our panel discussion, I have a few brief announcements. For those of you who would like to earn MCLE credit for today's webinar, I direct your attention to the URL on the screen, tinyurl.com/bb-whistleblower2. You'll also find this link in the chat, and that'll be there throughout the duration of this program. So if you don't fill out the form right now, please be sure that you just click on that link, complete the form, and at the end of the webinar, we will send you a certificate of attendance. Berkeley Boosts is just one part of our larger executive education program at Berkeley Law, and I want to take a few moments just to tell you about some upcoming programs. The first is Sustainable Capitalism and ESG Online. This is a program that will be opening on May 11th that demonstrates how to integrate environmental, social, and governance considerations into business strategy. We then have our executive summer courses. These are classes that will run from mid-May through mid-August. They're run in conjunction with our professional LLM program, so you're actually in class with LLM students. The classes are taught by Berkeley faculty, and due to the continuing pandemic, these are all offered online this summer. Then we have our General Counsel Institute. This is a virtual program for in-house attorneys, and this year we're going beyond legal to bring together a wide range of executives from the C-suite and beyond to discuss how they work with and are impacted by in-house legal professionals. That course will be running over 4 half days in June. And then finally, I just want to mention that we have our third and final whistleblower webinar that will take place on Monday at 10 a.m. Pacific time. So please, I encourage you to join us for that. And if you haven't already registered, you can still do so. And then finally, we'll conclude this month with our final webinar, Women in Law, Policy, and Government. You can learn about all these programs at executive.law.berkeley.edu. So that brings us to today. Today's topic is the history and structure of the Federal False Claims Act's unique whistleblower provisions and how they became the US's chief fraud enforcement tool. I mentioned that our moderator today is Claire Sylvia. Claire is a partner at Phillips Cohen. She's an internationally recognized whistleblower lawyer and the author of a widely cited treatise on the False Claims Act. So with that, I'll turn it over to Claire and she'll introduce our panelists. Claire.
Good morning. And thank you, Jim, and thank you to the Berkeley Law Executive Education for hosting this series. Yesterday, at the first of these sessions on Speaking Up, we heard from some whistleblowers who provided us with truly inspiring stories. And we learned about their experiences speaking up and what they had to go through as a result of raising concerns about their employer's illegal conduct or conduct that they were concerned about. And we heard from journalist Tom Muller about the commonality of whistleblower experiences. And strikingly, for many of us, in answer to Erica's question about whether they would do it again, the whistleblower, knowing everything that they now know, the whistleblowers both said that they would and that they would be compelled to do what they did. So today we're going to talk about a law that seeks to incentivize people like the whistleblowers we heard from to speak up. That law, the False Claims Act, addresses a particular type of whistleblowing, that is whistleblowing about fraud against the government. There are a number of other laws in the United States that protect whistleblowers, but today we're going to zoom in, if you will, on a particular law and talk about the mechanisms of that law and how it incentivizes and protects whistleblowers. And later in the third series, we'll talk about how that law and those mechanisms were expanded to other fields. We're very fortunate to have with us today as panelists, two of the individuals who are most knowledgeable about this law. First, we have John Phillips, who in addition to being a Berkeley Law grad, class of '69, I think, and former ambassador to Italy under President Barack Obama, he's the person who is really the driving force behind the modern False Claims Act. Today, we'll get to hear from him about what inspired him to forge ahead as he did, and at the particular moment in history when he did. And we'll learn about the challenges faced along the way. We're then going to hear for the present part of our talk about the False Claims Act, we'll hear from Jeb White, who is President and Chief Executive Director of Taxpayers Against Fraud and the Taxpayers Against Fraud Education Fund, which is a nonprofit organization that educates the public and seeks to protect and defend laws that help protect whistleblowers and expose fraud. The changes to the False Claims Act that came in 1986, largely as a result of John's efforts, really spawned a new era of whistleblowing in the arena of fraud against the government. And today that law is responsible, at least according to the Department of Justice statistics, to returning roughly $64 billion to the United States since 1986. Most of that in cases initiated by whistleblowers. We'll talk a little bit more about today how in addition to recovering money for the Treasury, the law has fundamentally changed behavior in the defense industry, healthcare industries, among others. And lastly, we're going to finish up and talk a little bit about the future of the False Claims Act and some of the challenges whistleblowers face, even with the protections that this law now provides. But first, before we turn to our distinguished panelists, to set the stage, I'm going to start talking a little bit about the False Claims Act past and a very, very brief history about qui tam, which is the mechanism that underlies the False Claims Act. Qui tam is really a short phrase, Latin phrase, that means essentially he who sues for the king as well as for himself. This is a form of a lawsuit that originated in England in the Middle Ages and provided that individuals who brought lawsuits to enforce the law for the king would be provided with a bounty or share of the recovery on behalf of the kingdom. It was really used primarily for low visibility offenses, those that the government, a king in that case, wouldn't easily be able to detect and enforce. And you'll recall yesterday we learned from the whistleblowers that the value of whistleblowers is that they can see inside the room where the fraud is happening that other people might not have access to. So this concept of qui tam was brought over to the American colonies from England, and individual colonies, which did not have significant governments at the time and were really dependent upon private resources, started to enact qui tam laws where private individuals would be incentivized to sue and enforce the law. Once the United States was formed, Congress, the first Congress, adopted a number of these laws, also didn't have a significant Attorney General's office or Department of Justice to enforce the law, and also relied significantly on private enforcement. At the time, a lot of these laws had to do with things like enforcing customs laws, because that was really the source of a lot of government funding back in the early days. But the most significant law to use this qui tam mechanism was enacted during the Civil War. And that was really the first time that the federal government spending really started to explode. And with that wartime spending came inevitably war profiteering and fraud. And so Congress studied the problem and how to address fraud against the government and came up with this law that they passed in 1863, the first False Claims Act. It was signed into law by President Lincoln. The act allowed private individuals to bring lawsuits in the name of the government to recover for fraud and gave a successful whistleblower or successful private litigant half the recovery. The government just sat back and waited for the recovery. They couldn't participate in the suit. But the purpose of the law was really to incentivize people to bring these cases on the government's behalf. As one of the sponsors to the law explained, the law was based on an old idea of setting a rogue to catch a rogue, which he said was the most productive way of bringing rogues to justice. He said that his idea was to hold out a temptation, what he called a temptation or a monetary reward, to have a co-conspirator turn in his co-conspirators. But importantly, the law wasn't confined to that class. Or in other words, anyone who had information about fraud could bring a case, and their motive really wasn't what was important. So this law sounds like a great idea, right? But fast forward a century, I think it's fair to say no one had really heard very much about this law after the Civil War. And for that part of the story, I want to turn to John. John, much of this history really only came to light in the 1980s and in large part as part of your archaeology. Can you tell us a little bit about how you came across this law and how you first learned about this concept of qui tam?
Sure, I'd be glad to. Tell you my sort of history of this law. When I graduated from law school at Berkeley in 1969, I always had an inspiration or interest in doing public policy work. There wasn't many opportunities available at the time, so I started working in a private firm, O'Melveny and Myers. But while there, this new concept took form from the Ford Foundation of sponsoring what turned out to be 5 groups to do public interest law. They would give you grants so that you could represent unrepresented interests. And that really intrigued me. And so I, with 3 colleagues, went to Ford Foundation and said, we want to go out and try this concept out because all these new laws are being passed and not all of them being successfully executed. So we did get the grant, but always we're concerned about where the money comes from. And that's what led me to the qui tam provision, because we had 50% of our money from Ford. We had to go out and to become sustainable, raise 50% from other sources. So I was always on the quest for how are we going to fund ourselves going forward. Clients didn't pay us fees. We were civil rights cases, environmental cases that we brought. We had to figure out how to underwrite them. So 10 years after we started this work, actually, 10 years, I was researching where else can we get support for our efforts. We would look at foundations that supported like nuclear power issues and things like that. In doing that research, I came across this extraordinary law I had never heard of, called the False Claims Act and called the qui tam provision. I dare say nobody had heard of it. This was been early 1980s. And what struck me as so profound about it, it gave you the standing. You could be a private attorney general representing the United States government going after the companies and people who are defrauding the government. That was extraordinary. And if successful, as Claire mentioned, you could collect a percentage of the recovery. But the law had been completely dormant since 1940s. Restrictive court interpretations limited its application. But I thought if you could modernize this in today's jurisprudence, this is back in the 80s, this could be an enormously powerful tool because there's so much fraud being reported then, defense contractor fraud, healthcare fraud, but very, very little of it ever getting recovery. And so I thought if we could amend this and take it back to Congress, a 2-year period of drafting what I thought would be the right fixes to the law, did that. Now, how do you get it passed? That's a big challenge. I went first to Senator Charles Grassley, a very conservative Republican from Iowa, since he was the most outspoken critic of the failure of the government to recover funds that are being defrauded by unscrupulous contractors. And he also was protective of whistleblowers. So I didn't know him. I went to him and his staff and said, here's something you can do about it. Take a look at this unique and very different approach, although it's rooted in history, as Claire mentioned, way going back centuries. It actually goes back, if you look far back enough, to 2,000 years ago in Rome. I discovered when I was over there as ambassador. So I said, here's something you can do about it. You got to modernize it and make sure that the people who filed this case are parties to the case and have all the rights to go with it. It gives you a seat at the table. You can represent the United States. You're guaranteed a minimum recovery. This is the amendments that I was drawing. That they can't give you less than 15%, up as high as 30%. And it's based on treble damages since it's a fraud statute. You had a right to object to settlements. If you thought they were inadequate, it's a tough test to meet, but you could do it and gave you a lot of authority and power at the table. And you had whistleblower protection provisions to, as best you could, protect them. You can't always protect them, to give them some defense mechanisms, because invariably whistleblowers often are singled out and punished. So that was the concept, basically, took it back there. And I also went to Howard Berman, a congressman, liberal Democrat congressman from California, a good friend of mine, who was also on Judiciary Committee. I introduced them. They shook hands in Grassley's office and agreed to introduce it in the House and Senate. That began a 2-year process by which we presented this as a bipartisan approach. This is something everybody has a stake in. And one of my favorite quotes I want to read is, there's no kind of dishonesty into which otherwise good people more easily and frequently fall than of defrauding the government. Benjamin Franklin made that comment years ago because the fraud was so rampant back then. They both embraced it. I said, this is bipartisan. Everybody's against fraud against the government. We went through 2 years. I won't take me a long time to describe the hearings, but we got through. We didn't want to oversell it to say it's going to solve all the problems. We didn't want to attract the defendants here who would see the risks associated with them. So it was a very generalized phrase bill. Anywhere the government spends money. It wasn't a defense contractor fraud bill. It wasn't a Medicare fraud bill. If you did that, you would immediately attack the opposition of those industries. Well, they were a little, the defendants side of this, I call them the fraud lobby, was a little slow on the switch. I'm realizing the implication of this, but we did get it through. We got through the Senate Judiciary Committee, the full committee, and we got Reagan to sign it. And we said, this is a Republican, Democrat supported proposition. It uses the Reaganomics of the time. Don't create marketplace incentives to do the public's work. Don't add to the bureaucracy, public-private partnerships. It sounded all in the themes that were very consistent with what President Reagan was advancing. And the Democrats, everybody liked it too. It's against, we're protecting our public fisc that's being so ripped off here. So we got it passed, but that's only the beginning, of course. Nobody knew about this law. Nobody knew the new law was passed. How do we get it educated and people understanding what this law is, who might be able to use it? And that followed a 6-year period where we were trying to bring cases, trying to educate the public. We had 60 Minutes do a story. We had LA Times, Wall Street Journal about this new law, because otherwise no one will hear about it. And then we filed some of the first early suits. That's where people learned about it in the press. The LA Times wrote this big story about a healthcare fraud case that we brought, and we got so many other healthcare fraud cases that came just because they got educated by that. But you also have to show that it's going to work. I mean, these whistleblowers take enormous risks, personal and professional risks. They're not going to be easily say, oh, it's a new law. I'll bring the law and I'll get rich and solve the problem. It's a very risky course of conduct to follow, as we know how whistleblowers have been treated. And will this law really work? That was a question. It was untested. It was a nice concept, but there was no evidence that would work. So the key thing was educating the public about the law, getting the first cases publicized, and when successful, getting them publicized to show that it'll actually work. It wasn't until 6 years after the law was enacted, in 1992, that we got some of the first significant recoveries. That's how long it takes. It's the investment of time and resources. Remember, there are two basic propositions that play with this law in terms of public policy. Number one, it wants to bring to the surface all of this undisclosed fraud being committed against the government. It's like an iceberg. 90% of it is below the surface. We're never going to learn about it. So how do we create incentives for the people on the inside, people who have the knowledge, to come forward and take the risks? That was the key for them to do. Secondly, it's going to bring private resources to bear to pursue government claims. People think government has unlimited resources. Oh, they'll go out and man as many attorneys as they want. Well, that's simply not the case. And I think if you really added up all the contributions that by private counsel, and in these cases each year, it will surpass what the government invests. And that's private money. That's private money that's going to be lost unless you're successful. So it is a risky proposition. So our goal was to get these cases filed, realizing it's going to take a long time, and get a pipeline of cases and try to get as much advanced education and coverage of these cases when they come out. Well, over the 90s, especially going into 2000, this thing grew exponentially as it was understood and as it worked. It actually worked. People were bringing cases, coming out the other end successfully and getting compensated. And so that's exactly what we wanted to establish in terms of its credibility. And now, moving into 2000s, the last 20 years, everybody knows about this law. Anytime you read an article in the New York Times or the Wall Street Journal about corporation XYZ paying $200 million or $300 million or $1 billion back to the Treasury, you can be sure it's from the whistleblower provisions of the False Claims Act. 85% of all the recoveries today that are obtained by the government come from cases initiated by whistleblowers. Only 15% come from the government-initiated cases. That shows you how extraordinarily successful. What used to be about $25 million a year in the whole United States recoveries now is in the range of $5-6 billion a year. And as Claire mentioned, the deterrence is where the real payoff is, tackling systemic fraud schemes. Once they're exposed, everybody stops doing them. That's certainly the case with the false claims cases that are brought. You attack not just one company, but everybody in that company who's been engaging in similar practice knows they're now at risk, and they stop it. That's the big payoff. 10 times what, and I think it was my own calculation, looking at this going back 34 years, it saved probably $1 trillion to the Treasury. And it's much more than the government only reports, 65 million. It's probably more like 100 million if you count the state recoveries and the criminal recoveries that are associated with those. But it's about $1 trillion. So it's been extraordinarily successful. And we created Taxpayers Against Fraud at the same time the law, and Jeb's going to talk about that, the law was enacted because we knew it would come under attack by the very industries that was challenging. And sure enough, the defense industry organized first to take it on, then the healthcare industry. But Taxpayers Against Fraud's role, when it got resources, was to defend this law and help professionalize the practice. And it's done a superb job now. And there's a thriving practice across the country in a whole new area of jurisprudence that didn't exist 32 years ago. That's very successful. I don't know how long I've been going on here.
I was going to interrupt you and just ask you a question about what led to that success. Yesterday, we heard from whistleblowers about how they would do what they did. They'd feel compelled to do what they did. One from an English system and one in an American system who brought a False Claims Act case. Can you tell us a little bit about what were the key incentives or removals of disincentives that are part of the False Claims Act that may have contributed to the success of the law?
Well, yes.
How does it work?
The disincentives before was there was, nothing but risk, no upside potential at all. And if you want to become a whistleblower in your company because you're just offended about the callous disregard they have for integrity in processing the government's claims, you had nowhere to go. If you were to expose this, the likelihood of you having your job is greatly diminished. People get harassed. I mean, you see the history of whistleblowers in terms of divorce, in terms of suicide, in terms of losing their homes, in terms of all the bad things that happen. This was going to be the good news to help whistleblowers. You can come in and feel a level of protection and an opportunity and do the right thing. Our experience is that they're motivated because they don't like to be part of if they're in a company that's doing this or witnessing this, and they feel compelled to do it. This law entitles them and empowers them. And that's that, and it's worked. And now that you see it working over and over again over the last 36 years, more and more people believe it will work and are willing to take those risks. So that has taken root in our system now of jurisprudence. And it's been so successful, we'll talk about later, it's been expanded, the same concept, private enforcement of public laws has been expanded into other areas, fraud in the marketplace, consumer fraud, all sorts of other areas that we can talk about. So it's not only successful in this area, the mechanism is extremely efficient. You don't get paid anything unless you're successful. So you're taking risk, you, the attorneys, and the plaintiffs to go forward. And these cases can take 10 years. You can have millions and millions of dollars invested. It's complicated, it's difficult, but it's very rewarding work. You're wearing a white hat, you're going after the bad guy, and it's true both for the clients and for the lawyers. I think lawyers who work on these cases in law firms love the cases because they feel so righteous and good about what they're doing. And that's good too. Usually the people who work at the Department of Justice, they want to pursue similar lines of work when they leave and they're doing this work. They had to go work for the defendants and defend them, the very people they were prosecuting. Now they have an option of trying to go out on the plaintiff's side. It's risky. It's not easy, but it can be very rewarding and very lucrative if you're successful. So the last thing I'll say about making money, where people say, well, all this money is being paid. It's paid for the risks that you take. And I tell you, it's very risky. Lots of failures too. Lots of lawyers and others who bring cases that aren't successful pay a heavy price. But it's the point I was going to make is my mind. It's anyway, it's been very successful.
Well, so that's an amazing history. It sounds like you went from this idea in your head about how to incentivize whistleblowers to now we're recovering $64 billion for the Treasury, and it was all smooth sailing. But I guess I'd like to turn to Jeb, who came in at to take his first job at TAF at a period when it was questionable whether this law would even survive. There was a challenge to the constitutionality of the statute. A number of entities who had been sued under the statute claimed that whistleblowers or qui tam relators didn't have standing to sue in the name of the government. And in a very important decision, the Supreme Court determined that, in fact, these private individuals did have standing. At the time the Constitution was adopted, there were qui tam suits. So certainly the people who wrote the Constitution considered these appropriate types of cases to be in the federal courts. So that's where you entered, Jeb.
Yeah.
And can you tell us a little bit about some of the areas in which the law started to make a difference?
Yeah, absolutely. And Claire, thanks for inviting me today. And John, it's always fun to join one of my good friends talking about the False Claims Act. So yeah, Claire's right. When I came and joined Taxpayers Against Fraud, I came straight out of law school. Prior to law school, I'd worked in corporate America. And while I was there, I recognized all kinds of things happening that probably shouldn't have been happening. And I decided to go to law school to try to better understand what protections are available to whistleblowers. This was pre-WorldCom, pre-Enron, pre-Sarbanes-Oxley. There wasn't a whole lot available. And when I was in law school, I worked for a law firm that was looking at the False Claims Act. And I became very interested in after I left law school, I joined Taxpayers Against Fraud as a staff attorney, and I became the in-house nerd on the False Claims Act, studying everything I could, which back then wasn't a whole lot. I read every single published circuit court opinion in a weekend back then. Now it would take you quite a bit longer. But Claire's right. At this U.S. Ex Stevens versus Vermont case that she talks about raises this question of whether or not a relator, a whistleblower, has standing under Article 3 to be a relator or to bring the case forward. It's a constitutional concern. Supreme Court decided in favor of the qui tam statute, blessed the constitutionality of it, and that opened up the doors and gave the Supreme Court seal of approval for the False Claims Act. Allowed relators a level of certainty to file these cases without concerns about the act itself being deemed unconstitutional. Since then, over the last 21 years, cases have been filed in every industry. As John talked about, this originally was a kind of a defense contractor, then kind of got into the healthcare world. Now every part of the government money is protected under the False Claims Act. There's fraud impacting government programs, government dollars. The False Claims Act is going to arguably apply. So especially in this era of increased government spending, especially over the last 12 months, there's increased need for the False Claims Act and whistleblowers to protect that money. So since then, as John talked about, $64 billion, the number is probably going to exceed $70 billion by the time we're done this year. 85% of those dollars have happened because of whistleblowers filing cases. The government gets back probably even higher now, $22 for every dollar invested in qui tam cases. And the reason is very simple. Without whistleblowers, the government really is kind of hacking at the leaves of fraud. And the whistleblowers say, no, the root cause, the problem here is here, right? They're able to point inside the corporate wall saying, this is the mastermind of the fraud. This is where the corporate documents, the skeletons are hidden, and allows the government to effectively and efficiently go after those fraud schemes in a way they simply can't. As these fraud schemes have become more and more complex, the need for insiders has gone up. And that's what's happened. It's touched every single industry. Everywhere you see government dollars involved, there's likely been some kind of False Claims Act case brought involving relator stepping forward.
Thanks,
Let me make one quick response to Jeb to appreciate significance, especially the point I made about bringing private resources. I'll just cite one case, It went on for 10 years. It was a huge case. And it was one that was very complicated, involved a for-profit hospital with 350 hospitals, a systemic practice. But I won't get into the details, the complexity of it, but a couple observations. If we just gave the information to the government and say, here it is, go after it, nothing would have happened in that case because it's complicated, because it took a lot of resources. Once we got down to the point where we had to litigate it, the defendants came to the Justice Department and said, you can't, this case is too complicated, too big, you can't try this case. And they panicked, thinking they're going to have to try it. And they came to us and said, we need 22 full-time equivalent lawyers for this case. That's how big it is. And we can only provide 2. We said, okay, we'll provide 20. And we did. And at one point, we had 70 lawyers working on that case around the country because it was a complicated case. And we settled that case, if you add in all the related cases to it, for $1.7 billion that never would have been recovered because there were no resources there to pursue the claim. It was the private resources that drove the case, even though the government joined. And that's how important that provision is and why it's so effective.
And Claire, that's a huge point right there. In addition to, John's talking about what the government said, invest your resources, hire people. There's certainly been a lot of cases where the government did not intervene, right? Did not join the whistleblower. And the statute's written in a way that we as relators counsel, as whistleblowers counsel, can move forward without the government. They may decline because of limited time, money, and resources, or for whatever reason, and still move the case forward, recover for the American taxpayer dollar, and make good case law that then becomes the foundation for subsequent case law. A lot of the cases that we're now recovering on were brought about because relators made great case law involving kickbacks or off-label marketing or you name it. A lot of it really was the foundation because the relator decided to go forward without the government.
Yeah, that's an important point, that one of the significant changes in 1986 was to allow private individuals to pursue the case on their own, but the government can also join their cases. I guess before that, it was an either or option. And now the government can join and proceed with the whistleblower or allow the whistleblower to go on their own. I have a question for both Jeb and John. When I first was introduced to the False Claims Act, I was always of the understanding that as a matter of economics, eventually we should be out of a job as whistleblower lawyers, because if enough of these cases are brought and they recover, basically the liability is treble damages and penalties. The idea being that if you bring enough of these cases, companies internalize the requirements and they police themselves. And so we will no longer have any work. And yet it seems like the more cases that are brought, the more work that there is. We're only scratching the surface. Is this law not really making any difference in behavior? What do you see in terms of deterrence and compliance?
So I would point back to John's quote from Benjamin Franklin, right? There's no kind of dishonesty, otherwise good men follow. But it's just this greed is hardwired, unfortunately, into a lot of people, and it drives people to make decisions they probably shouldn't. And the one thing that we see, it's interesting if you become a student of this area, is you'll see fraud schemes apply to one industry, and those same fraud schemes will be applied to the next industry, right? There's every single day, our economy is adopting new industries and new jobs are popping up that we simply can't imagine. But the old fraud schemes remain the same. It's just simply taking the same playbook and applying it in a new way or to a new area.
John, you're on mute. You're on mute.
There's noise here. It's a risk assessment based on the defendants. Before the risk was very low. If you're engaged in a Medicare program being compensated by a Medicare system, audits were almost non-existent. You could figure out schemes that would easily overcharge the government. They would never find out. Now, because of this law, because of people inside who know how the system works, they're at risk, and they could even be criminally charged if the evidence comes to the fore that shows they were criminally engaged in criminal misconduct. So the risks are very great, and that's where the deterrence comes. In the case I just described to you, the reason it aggregated so much is because they never got audited. Never. They would even keep two sets of books if they did get audited. What would they have to pay back? It was like a Rosetta Stone that we got access to that showed what they were doing. So that practice has continued, but it's really been blunted in some areas because the risks today are substantially increased.
So, so Jeb and also John, can you give our listeners some examples of cases where the False Claims Act has been brought to enforce the law? I think people can understand sort of some basic types of fraud, for example, double charging for tanks or bribery or things like that. But can you give them some examples of where the False Claims Act has been used to recover money that might be a little outside the box in terms of how people think about fraud?
Yeah. We talked about some of the old, what is old is new again. Originally, the False Claims Act was put in place in 1863 in response to people selling lame horses to the Union Army. The same thing happens today, right? Except instead of horses, it's now defective Chinook helicopters or bulletproof vests that maybe aren't bulletproof. So that's a common one. Or when the government puts out a request for projects or people to step forward, they have certain things that must be met. There's contractual requirements. So somebody may submit a claim for payment, and the goods that they provided simply don't comply with the regulations or the contract. Another good example is somebody applying for money. It's happening a lot right now, and they aren't eligible for it. So small businesses that are actually large businesses. John has one of the great examples of that happening in the Gabelli case. There's a lot of, the government doesn't give money away, right? They oftentimes have certain strings that are attached, conditions, requirements that must be hit. And when people submit saying that they are compliant with those and they aren't, by and large, that's about half of the cases that we're seeing. And then the other ones are simple, upcoding cases. People in the healthcare world, you can think of them submitting for upcoding services that weren't really provided as a common example.
Three quick examples of who the whistleblower was that was envisioned back at the beginning. It wasn't just insiders and companies. There's of course, the people who have most access and see the fraud unfolding in front of their eyes. It's also a competitor. For example, this one labs case, we had a blood testing lab. This was a competitor who had his own field of doctors who used his lab services, and he kept losing them, couldn't understand why. He saw his competitor coming over and offering a scheme that would encourage doctors to order medically unnecessary tests that would make their companies much richer, but the doctors didn't have to pay anything extra. It was a deliberate scheme to get them to order tests that they otherwise would not order because the government paid on a per test basis. So if you can come up with a scheme where you check a box and you get 2 tests, not just 1, that's the only way you can get it. So that's a competitor who saw it out there. The other one I described about the accountant in this hospital chain, he was an auditor. He was a CPA inside a company, and he discovered this 2 sets of books. And he said, I can't do this. This isn't professional. And so very quickly, he got sort of pushed out. So he's an insider. And the third one was just a guy who's knowledgeable and a lawyer in practices out there. This was on the Gabelli case that Jeb referenced, where he knew these companies competing for these wireless spectrum auctions were going. He recognized all these names in there about who the petitioners were, who the applicants were, and he started doing his own investigation and discovered they were all fronts. They were fronts for this guy Gabelli, and the reason you had fronts is you were getting discounts. If they were small business, you got a 20% discount in the price. So he's motivated. The guy from outside, we hired our own investigators to go out and pin down some of the facts, and you're able to do that. That's that was encouraged by the law. So those are 3 different categories of people who can use the law effectively through their own initiative and their own knowledge that they see just where they're working internally within the company.
So that's really interesting. I think a lot of times people think of whistleblowers as just employees at a company reporting fraud. And obviously that's a situation that occurs often, but it could be a competitor, it could be a person studying an issue and seeing something that other people don't see. But what about, we talked about at the beginning, one of the proponents of the original False Claims Act talked about co-conspirators. What about people who plan the fraud? Can they also be whistleblowers and get rewards? That sounds sort of not right.
Well, we had the original law passed in '86 had no provision in there to deal with precisely what the circumstances you're raising, Claire. And we worried about that later, especially there was one case I know that two guys who were planning on using the law were in jail, were in prison. And I said, that would be a terrible example. So we got an amendment passed through that said if you are a planner or an initiator of the fraud, in other words, you were a principal involved within the company, you would not be eligible to use this law. And but you can't, the companies tried to say, well, he was involved, he saw her, she was involved, she knew what was going on. They were, but they didn't like being involved. And this gives them an outlet. And these are people who are being forced internally because of company policies and practices to keep quiet. Now that this law gives them out to go after and to do what their conscience tells them to do. And that's where most of the cases come from the insiders.
So a difference between someone who's a leader of a company who plans the fraud and somebody who works at a company who's doing it because that's their job.
You've got to get people on the ground level of these companies, people who know the fraud. They can't, even though they know about it, they don't have some duty and obligation to go right to the authorities. They wouldn't do it before, but now this law is sort of an intermediate step. You can protect yourself, you can be a good citizen and expose the fraud, and good for you if you're successful.
Yeah, that's such a great point, Claire. John talked about the professionalization of our bar and the other part about public education. Both those things continue. This idea that, I can't come forward because I saw what's happening on it and I didn't do anything immediately. This say something, do something concern. A lot of people call us, they call John or Claire or other people that are in our bar because they're worried about their own culpability. And then after talking with them, you didn't recognize, wait a second, you're actually exactly the kind of person that we need to step forward. You weren't a planner or initiator of the fraud. You were a witness, right? And you're the kind of person that the government wants to come forward that you can help us move these cases forward in a good way.
Thanks, Jeb. So to bring this a little bit full circle back to Berkeley, one of the things that we talked about yesterday were the challenges that whistleblowers face. The whistleblowers talked about not realizing, going into it naively and not realizing that they would not be working in their industry again. They couldn't get a job everywhere they went. People seemed to initially think that they were a great candidate, and then for some reason, they never got the job. And it would dawn on them later that maybe people knew that they were a whistleblower and not the type of person somebody wanted on the inside. There are other kinds of challenges that whistleblowers face. And one of them is getting sued. Do you want to talk a little bit about that? Sued for taking documents, that is.
Yeah, I mean, that happens quite often, and there's this threat of litigation that happens oftentimes. There's provisions in the HIPAA law that comes into play as far as protecting you if you bring documents, to evidence the fraud. It's always something that you have to talk through with your counsel. But the E in email stands for evidence. A lot of times these documents help back up and corroborate your allegations. And, working through this with your attorney to make sure that you're doing it the right way is always an important thing.
So why are documents important? Can't you just go to the Department of Justice and bring a case and say, here's something that I know that's happening, and they'll join your case?
Yeah, so John talked about this, and I think you did, Claire, this idea that the government has unlimited resources. I haven't found it. It's simply not true. It's simply not true. So the government, they're not looking for low-hanging fruit. A lot of times they're looking for boxed fruit, right? You have to come to the government with, here's the evidence, here's the draft subpoena, here's the org chart. You want to make sure you talk to this guy. It's that level of detail that catches the government's attention. There's 700 cases filed a year. The government intervenes in about 15-ish% of them. So, making sure that you have not only allegations of fraud, but evidence to back up what you're saying goes a long ways to make sure that the case is going to be successful. And as Claire talks about, it's not an easy road. So if you're going to be risking your career, you want to make sure you're doing it in a way that's going to put you in a position to succeed. And a good lawyer is going to make sure you do that.
Yeah, we've had lawyers who themselves thought hard and long about whether they could become a plaintiff. And that raises other issues too. But when they do the analysis and say, I'm making a lot of money now, if I do that, it will, even though I'll make millions, it will cost me more. And we've had potential clients who've actually walked away saying, I just too much of a risk for me to take.
Yeah. So one of the questions that we often got from whistleblowers when they would come to us is, can I be sued? And we used to say, yes, anyone can sue you for anything. But you have a good defense, which is public policy. The False Claims Act requires you to give the government your information. And for a while that worked, but then courts started to allow those cases to go forward. So just again, to bring it back to Berkeley, in a law exam, in a intellectual property case course taught by my spouse, actually, they asked the question, could you have an immunity provision allowing whistleblowers not to be sued for trade secret violations when they turned over documents to the government solely for the purpose of supporting investigations of misconduct. And that became law, partly with Senator Grassley's backing. And so those materials are in the readings for our guests today. I don't know that that's received a lot of attention yet at TAF. I don't know if you, Jeb, do you have any comments on those kinds of challenges that people have been facing?
Yeah, it doesn't seem to be catching a lot of people's attention. It's something I highlight quite often. But I think this does highlight an important point to make, Claire, is that over the last 40-ish years now, a lot of bad case law has been made. And the False Claims Act was not touched from 1986 all the way to 2009. And then because of people kind of pushing on the law and the fraud bar pushing in the opposite direction, bad case law was made in Congress, led by Senator Grassley, fixed a lot of these things to make sure that whistleblowers are better protected, including strengthening the anti-retaliation provision. So, it's always this kind of give and take over the years that eventually you have to go back and tune up the car. And Congress has done that periodically over time.
So what are the some of the recent changes that Congress has made in 2009? Can you tell our audience a little bit about that?
Yeah, absolutely. So yeah, 2009, the FARA amendments, they're a great read if you're having trouble sleeping. The biggest one was this question about whether or not government money stolen from a third party is reachable by the False Claims Act. Happens a lot, right? Medicaid receives money, they pay it out. Your Medicare contractors paying out money. There's a lot of, we rely on contractors to pay out government money in a whole lot of examples. And courts were starting to get that wrong. And Congress said, no, we want to make sure that all government money, even money paid out by a third party, is protected. Subsequent amendments happened in 2010, 2011, also to strengthen, clarify the public disclosure bar, which is something we haven't talked about. This idea that you can't just take a newspaper article and file a complaint based on the allegations that are in the newspaper, unless you had your own kind of independent knowledge of the fraud. Congress went in there and made sure that that was clear exactly what was allowed and what was not allowed under what's called the public disclosure bar. So, those were kind of the biggest ones, this idea of making sure that all government money, regardless of the payor, is protected. And then also making sure that these kind of defenses that the defendants were using were not overly broad, thereby wiping out meritorious claims.
Thank you. So we have a couple of questions to clarify some of the issues under the False Claims Act. One question is, can someone debunk the concern about people going into organizations and turning over every rock to determine that there's the smallest technicality that some company has not complied with. What about that? Does the Act provide any protections for corporations that are being attacked for really minor technical violations?
Well,
go ahead, John.
That doesn't happen. First of all, it just doesn't happen. You don't want to go out and find a technical, if you're the plaintiff here, a technical violation, some minor, it's not worth your effort. It won't be successful. There are no nuisance settlements here. The government must approve of any settlement that's to be obtained. So people will say that, they'll go out and file frivolous lawsuits. I remember in the hearings back in 1986, this is just to encourage the number of frivolous lawsuits to be filed. And my response was, well, why in the world would you file a frivolous lawsuit? You're not going to make any money. You're going to eat up your time and come out the loser, because you have to file meritorious cases that are substantial and significant to justify the government's going forward and you're going forward. And there's no person just joining a company, turn over every rock in here and find some bad thing that they did. That doesn't happen.
And the other thing that happened in the FAIR Amendments 2009 was this materiality standard was codified into the law, saying that it must be capable of influencing the government's payment decision. So some foot foul or minor violation simply isn't going to rise to the level of triggering the False Claims Act unless you're able to show that it meets that standard.
I think that's an important fact. So it has to be a material violation, something that matters to the government. And small technicalities aren't going to rise to that level. To John's point, the law also provides although it provides attorney fees for plaintiffs who are successful, it also provides for attorney fees for defendants if a lawsuit is truly frivolous or brought for vexatious reasons. Somebody's really out to get the company and just attack them for nothing. That might be a situation where the company could seek fees against the person who brought that. That doesn't happen very often because it doesn't happen very often. So another question is whether the provisions relating to whistleblowers accelerate the remedy to the person wronged in some way. Do you want to talk about that? How long it takes before the person who brought the case might ever see any recovery, either for having lost their job or for getting a share of the recovery for the government?
They can take a while. And as attorneys, I always tell my wife, it's like you have a second marriage. Like you're going to be spending a lot of time as an attorney with this client, sometimes years. When I was in private practice, we had a case that settled after 12 years. There's other cases that I think they've reached 18 or 19 years. By and large, they tend to be around 5 to 6 years. But yeah, it can be a lengthy process.
And remember, you get nothing while you're financing the cost of that litigation, and especially if it's intense, like the case I was describing. We had 70 lawyers. Well, we were paying all that out of pocket and our fees. And this is the other thing, you get fees if you're successful for the plaintiffs for the time the attorneys put in, paid by the defendant to the plaintiff's counsel. And those fees can be substantial, but the fees that in our experience that are greater here, if you want to get an average, the people who are really making money on it is defense counsel. You go across the board and see the plaintiff's counsel versus the defense counsel and the average fees that they would get. It would be dwarfed by the defense counsel because the stakes are very high and these cases are thoroughly litigated and you can put a lot of time and effort into them.
So that's true. So here's an interesting question. I'm going to throw this to Jeb. One commentator says, government money, isn't there a concept of people's money? And we haven't talked very much about that, but I'll let the head of Taxpayers Against Fraud talk about that.
I don't know where we're going on that one. Yeah, I guess it's the people's money. That's right. We're there to protect the American taxpayer. These are American taxpayer dollars that we're recovering. I can show my cards as a Republican. I want to make sure that every dollar that we are spending is done correctly and appropriately. And those dollars that are stolen, we are recovering for the American taxpayer. That's what the False Claims Act is about, right? It is making sure that the taxpayer dollars that are used for government programs are used correctly. There's a separate program for the IRS, separate program for the SEC, but when it comes to government programs, you're right. It's us as American taxpayers footing the bill on that.
Yeah. And one area it could be expanded to in a more effective way that we've been talking about, lawyers on our side, is tax failure to pay taxes, IRS. That's where the money is. And right now, there's been recent articles addressing what they think the shortfall of failure to pay taxes due is up to $1 trillion a year now, estimates. Now, under the False Claims Act, it doesn't apply to taxes. There is a provision in the IRS rules that give you some opportunity to present complaints to the IRS, but you have no control. This is a case where you're not a party to the action. You just leave it up to the IRS to call me when it's over, whenever you come back with something. Well, they never do because they don't investigate. They have too many of these things filed, and the audit level is very, very low. If they were to amend that provision to say you can bring a key TAM action against a company that has failed to pay taxes owed, and you have a jurisdictional minimum of several $1 million because you don't want to encourage small cases, that this is covered by the key TAM provisions, gives you the same right of access. I think that would result in billions and billions and billions of recoveries being paid and people paying the taxes that they owe. Instead of increasing taxes that everybody hates to see, how about collecting the tax revenues that are obligated to be paid but aren't being paid? It's a lot of money.
And so that's one of the things that we'll talk about on Monday, which is the future of spreading this idea to other areas. The last question I just want to touch on, maybe one we should have answered right at the outset, is what is this cause of action? What do you have to allege when you bring a False Claims Act case? Jeb, do you want to take that just briefly?
Yeah, there are certain elements, right? It's a false claim. So the claim is a claim, a demand for payment, or a demand to keep money that you've received, and it must be false. So it must be false in some way. It violates a contract we talked about before, some express condition. You're claiming that you're a small business when you're not. And then there's a knowledge element that's defined under the act, either as knowing or reckless disregard or deliberate ignorance. So those are the big elements that come into play. Of course, there's some other ones that we always argue over, but a false claim seeking government money or the people's money from a government program that's false.
And so at the end of the day, to recover damages for the government, you have to show damage to the government, which would be another element. But what if there wasn't any damage? Maybe the government caught the fraud before they paid out. Can you bring cases where you're not really sure how much damage there was to the government?
Yep. So there's also a civil penalties provision as well. Mm-hmm.
Well, you could bring cases, but it's not sure you're going to recover much. I mean, one of the important assessments you do as the attorney is what do you think the damages here would accumulate to? And can you get double or triple the damages because it's a fraud scheme? And if it doesn't measure up to something that's going to justify the enormous risk you're going to take as the whistleblower and the financial risk you're going to take as the lawyer, you've got to do the balance there and say that this is worth doing. So a lot of cases don't get brought because even though there's fraud there, it's not significant enough to justify going forward with a cause of action.
Yeah, that's a great point, Claire. I just want to highlight for everyone. So we talked about earlier about the government joining the case, intervening in the case. And although you have the ability to go forward without the government, it's a lot easier to do it with the government. So our initial goal is to get the government interested in that case. And by highlighting, look how much money has been defrauded by the government from the government. That's a huge selling point in addition to highlighting, potential patient harm or other plus aspects. But that dollar amount is important to get your mind around.
And then we maybe have a moment to answer a last question, which is for John. I think he'd be the only one who could answer it at this point, which is what is that Roman law you were referring to at the outset that was the origin of qui tam long before the Middle Ages?
There's a Roman name for it. It just escapes me now, but it's very similar. back in the days of not having sufficient enforcement capacity within Rome, and lots of money coming through there, and a lot of government, being ripped off. There is a name for it, and I'm sorry, at my advanced age, I can't pull all the names out.
Seems like it should be qui tam. It's Latin.
That's true.
It should be. It wasn't, though. It wasn't.
Well, I think we are at the end of our hour. Oh, and here's Jim to tell us that.
We are. I want to thank the three of you, Claire, Jeb, and John, for your time, for joining us today. This was a terrific conversation. And I want to invite everybody, if you're not already registered for the third and final installment of this series, please go to executive.law.berkeley.edu, register for the webinar. We'll pick up this conversation on Monday at 10 a.m. Pacific. And with that, we'll sign off. And again, thank you all. Thanks for joining us.
Thank you.
Thank you.
Bye-bye.
Thanks, Claire. Thanks, John.
Bye.